Welcome everyone to our first Innovation Business and Law Center speaker of the semester, part of our series on genetics, law, and society this semester. I'm thrilled to welcome all back in person. Super excited by this, that we have live speakers this semester. So today we're going to have Professor Anya Prince, who's going to give a talk, but we've got other speakers who are going to be coming up in the next few weeks. So I hope you can come and join us for them as well, whether you're on Zoom or whether you're here in our live audience. So I'm going to give a brief introduction to Professor Prince, even though many of you already know Professor Prince very well. Professor Anya Prince, his teaching and research interests explore the ethical, legal, and social implications of genetic testing, with particular focus on genetic discrimination and privacy, the use of big data and algorithms, and insurance coverage of genetic technologies and interventions. She's one of the leading, if not the leading expert on insurance and genetic discrimination. And we're thrilled to have her here at the University of Iowa College of Law. She's published in a wide range of journals, both traditional law journals as well as peer-reviewed journals. She's published in journals such as the North Carolina Law Review, the Iowa Law Review, JAMA, the American Journal of Bioethics, Journal of Law, Medicine Ethics and Genetics in Medicine, and many others. In 2015, she was awarded a 5-year Pathway to Independence Award from the NIH, to examine the use of genetic information by life, long-term care, and disability insurers. In addition to this grant, Professor Prince is an investigator consultant on multiple other NIH-funded projects. Before joining the Legal Academy, Professor Prince served as a postdoctoral research fellow at the UNC Center for Genomics and Society in the Department of Social Medicine at UNC Chapel Hill School of Medicine, as well as an intern in the UNC Hospital Ethics Committee. In addition to her research role, Professor Prince has also worked as a Skadden Fellow and staff attorney at the Cancer Legal Resource Center in Los Angeles, California. So with that, welcome, Professor Prince.
I'm happy to be here and happy to chat about some of this work. As Professor Montana mentioned, I had a 5-year grant that just recently ended to look at how life, long-term care, and disability insurers use genetic information. And this is the final project of that grant. So I'm both excited to do that because it sort of culminates everything, but also to just be done with that part of work, because after 5 years, it's a lot to do. So what I'm going to do today is talk a little bit about some empirical research that I did with some co-authors, talk about the implications for that research, and then I actually want to take a step back beyond just genetic and genetic information and think about implications of this research for privacy and anti-discrimination at large. Okay, so empirical research. So this is with co-authors Sonia Sutter, who's at GW Law, Wendy Ullman, she's a genetic counselor at Michigan, and Erin Schwerer, who's in the internal medicine department here at the University of Iowa. So really interdisciplinary, cross-university collaboration. And here was the impetus for this, right? There's fear of genetic discrimination out there in the world. Lots of evidence of discrimination out there in the world. So people who are going to take a genetic test, usually this comes up if you're asymptomatic, you're taking a predictive genetic test. Like, would I have a risk of cancer in the future? Would I have a risk of Alzheimer's in the future? And people are really worried that if they get that information, that somebody could then use that to discriminate, either employer or insurer. And there's actually evidence that this fear leads people to not participate in genetic testing and genetic research. And that's a big concern for public health because it could lead to loss of life. So Professor Rothstein made these arguments that if somebody, fails to get predictive genetic testing, and if they got that genetic testing, they could find out they're at risk of cancer. If they found out that they were at risk, they could go take preventive measures, get screened more early, and do something to mitigate their health. So if people are so fearful that they're not even participating in this, then it could harm public health. And then of course, if people don't want to participate in research, that affects public health at large because we don't make advancements if we don't have enough people in research. So, okay, wait, what about this fear of genetic discrimination? Arguably, this fear is simultaneously too narrow and too overbroad. So let me explain what I mean by that. So many people, when they're worried about genetic discrimination, they in particular cite a fear of discrimination by life, long-term care, and disability insurance. Those are the main three actors that people are really worried about. And it's that category that I argue is simultaneously too limited and too overwhelmed. So what do I mean by that? Well, first, too narrow. So in the US, federal law, we have the Genetic Information Non-Discrimination Act, or GINA. So GINA prohibits health insurers and employers from both collecting genetic information and using that genetic information to discriminate. So by that, I mean they can't charge different premiums, they can't fail to hire you, they can't fire you, all those sorts of things. And there are some common gaps that are cited in GINA. In particular, in the case of employment, it doesn't cover small businesses. This, though, tracks all of our federal anti-discrimination law. And if you're in have learned about other laws, it tracks the Americans with Disabilities Act, it tracks the Pregnancy Discrimination Act, it tracks some of our racial and gender federal laws. So many state laws fill that gap. And then the other gap that is commonly cited is it doesn't cover life, long-term care, and disability insurance. So people often focus on that. Why do I say that this is too narrow? Well, what about every other gap in GINA? It doesn't cover an educational institution taking this into account. It doesn't cover the military. It doesn't cover mortgage and lending insurers or institutions. It doesn't cover auto and property. And there are discussions in many of these areas that people either have already used genetic information in some limited circumstances or that they're interested in it. I present a lot to insurance audiences, and I talk a lot about life insurers' use of genetic information. Whenever I'm done with that presentation, I get at least 2 or 3 people who come up to me and say, what about property insurance? What about auto insurance? Because to the underwriters listening to me, they think, I'd want to know if somebody has a predisposition to a neurological condition. That'd be pretty handy to know how I should underwrite, right? So they're thinking about this in terms of that'd be really useful data for us. Okay. On the other hand, this fear is arguably way too broad. Why? Well, there's actually not that much evidence that discrimination on the basis of genetics is happening out there in the world. There's very few noted cases in employment. GINA has been in place for over a decade now, and we've had a handful of cases. We've had 1 jury trial that I know of that's actually gotten all the way through and had a jury verdict. And as people in my genetics and the law class know, that was about somebody defecating in a warehouse and them trying to identify who it was. It was not about predispositions, right? Take genetics and the law, you get all sorts of fun, wacky cases. Also, in the health insurance realm, the Affordable Care Act came 2 years after GINA, and the Affordable Care Act says you can't take any pre-existing condition, anything into account when underwriting health insurance. And so the Affordable Care Act really sort of eclipses the impact of GINA in the space of health insurance. And then even outside of health insurance, there's pretty limited evidence of widespread use in life insurance, in other insurances. There is some. You have a predisposition for a really severe adult onset condition like Huntington's disease, which is a neurological condition that doesn't have any cure, doesn't have any prevention. Insurers are going to take that into account, right? But for a lot of genetic tests out there, it's just noise to insurance companies. And in fact, there's been some actuarial modeling that says if insurers were not allowed to take into account genetic information, what would the impact on the insurance world be? These studies are all around life insurance in particular, and they only pick 13 to 14 genetic conditions to actually model for the impact. Now, I can tell you, some of these authors, this is a Society of Actuary, this was commissioned by the insurance industry. There was going to be a bigger impact, they would pull in more genetic conditions. But these are just the ones that are adult onset, impactful enough, have severe enough traits and it actually affects mortality, because if it doesn't affect mortality, why deny somebody insurance? You're losing a customer, right? So pretty limited evidence that discrimination is widespread. And yet our laws don't protect a lot of places where people are interested in the potentiality in the future of using this information. Okay, so what did we want to do with this empirical research? We wanted to take a step back and say, why do people cite the fear of life, long-term care, and disability insurance so often? Where does that come from? And one hypothesis that we had is that that worry comes in part from informed consent language. So both when you're entering clinical genetic testing, but also when you're entering a research project, you'll get informed consent, or a genetic counselor in the clinical space will sit you down, especially with predictive genetic testing, and say, is this something that you want to do? Here are the pros and cons, here are the medical implications, yada, yada, yada. And they very well may mention gaps in gene, or protections in gene and gaps in gene. Okay, so what we did is between June and July 2020, we used this company called the Qualtrics Research Service to send out this survey to about 1,200 participants. And we set quotas for a wide variety of metrics to make sure that they mirrored the US population. So we had a really representative sample. And this is just to show that our quotas worked, right? We had really diverse income, diverse education, diverse ages, and this mirrors the US for race and ethnicity. So we had representative across different race and ethnicities as well. Okay, and then we randomized those 1,200 people into 3 separate groups. And there's a lot on this slide, and I'll walk you through it. Right, so let's focus on this one first. Health and Human Services has actually written up guidance that says, here's how we think that researchers should talk about the Genetic Information Non-Discrimination Act when they are doing informed consent. And so here's this language. It talks about GINA, says what health insurers and companies can't do. And then note here, the recommendation by the federal government is to specifically include this call out for the gap in GINA of life, long-term care, and disability insurance. And so many research studies include pretty similar language to this. So 1/3 of our participants received this language with this little prompt. Okay, then 1/3, we removed that last note, right? So we call this minimum disclosure. We just tell what GINA does, and we don't mention anything about what it doesn't do. And then in the final group, we said, why not throw the kitchen sink at them? Why not point out to them that it doesn't regulate all of these other companies? And then we asked them a whole bunch of questions after that. And so there's 2 that I'll focus on today. One is, after reading these statements describing the protections, how likely are you to participate in this hypothetical study, right? We had given them, to imagine that you're joining this study on diabetes or Alzheimer's. We gave them a couple choices. Okay, so what did we find? Overall, it was a 1 to 7 scale. Overall, people were pretty likely to want to join. We're nearing 5 out of the 7-point scale of very likely. But the people who received the minimum disclosure, that is no gaps cited in the law, were statistically significantly more likely to say, as a group, that they were willing to participate in that study than those who received any information about gaps in the law. Okay. And then we also asked, based on the informed consent language, do you believe you're at risk of genetic discrimination? So here we can see overall, pretty low, right? It's not 7 again is very likely. So we're not at, I'm definitely going to have genetic discrimination. We're at the bottom half of, pretty like skewing towards unlikely. But those who received the comprehensive with all the gaps of GINA thrown in, or a list of a bunch of them, were statistically significantly more likely to believe that they were at risk of genetic discrimination than those who didn't get that information, right? Who either got fewer gaps or, oh, actually, this was only statistically different from the minimum disclosure. So no gaps versus all the gaps thrown in, right? It changed how people thought about their risk of genetic discrimination. Now, both of these are about willingness to participate in a hypothetical study. That's going to affect it, right? There's a limitation to our study that we're just asking people to think about it. But it is interesting, I thought, to find out that this did affect how people think about genetic discrimination and willingness to participate in this study. We also did additional statistical tests where that was just, all of these were just comparing one variable, right? Or two variables, the consent that they got and their willingness to participate, or the consent that they got and their risk of genetic discrimination. But we also put into regression analysis all sorts of things to see if what was really underlying that was some demographic. And we found a couple of things that are interesting. We didn't go too much into it in our paper, but older age and higher political conservatism was associated with a decreased willingness to participate in the research. Whereas greater education, greater income, greater religiosity, and receiving the minimum disclosure, as I mentioned, were associated with greater willingness to participate. What is interesting for our talk here is that receiving the minimum disclosure was still statistically significant, even when you added all of the rest of that, the demographic variables in. So the power of that was really strong as a predictor. It wasn't just some happenstance that came about. Right? For perceived risk of discrimination, I personally was a little bit surprised that there weren't more demographic traits that might have come into play with this, but we just found that older age and receiving the minimum disclosure were associated with decreased perceived risk, and then greater religiosity was associated with increased perceived risk. I don't really have a hypothesis for why greater religiosity comes into play there. There's lots of actually literature about religiosity and health outcomes, which is why we threw those in. But again, the minimum disclosure still held to be statistically significant, even when adding in other demographics. Okay. We also asked some qualitative data. So help us to understand, right, not just a quantitative survey, you have to answer these things, but we gave some open-ended responses. So here was one that was, please explain, based on the informed consent, do you believe you're at risk of genetic discrimination? There's some really interesting findings here that I'll highlight. So one, people thought that, again, this isn't statistically significant, this is just themes that arose from one-off people, right? So these are just anecdotal. But family history or personal history of the disease really came into play. So half of our participants said that they were going to join a study of Alzheimer's. Half of our participants were told they were going to join a study of diabetes. The differences in disease didn't end up being statistically significant like anywhere, so we just don't talk about that much in our findings. But it did come up into play some in the qualitative pieces. But you can see here people say, well, I'm not at risk. I don't have anything in my genetics that will make me at risk for discrimination. Now, they haven't necessarily taken the genetic test yet to say whether or not they would find something, right? I mean, maybe they have, because maybe they've done a bunch of genetic testing, but people think of this in different ways. Also, people's life situation matters. So here's somebody who's retired and on Medicare. They're not worried about access to health insurance, access to employment, probably access to life insurance, right? It's their age that's going to hurt them for getting life insurance at presumably over 65 to be on Medicare, right? Versus I work for a company with only 5 employees. So I'm really worried about genetic discrimination because a lot is. This was a really interesting one. So we did not ask anything specific about racial discrimination, but multiple people brought up various pieces, right? We were asking about genetic discrimination, but multiple people brought up whether they were light-skinned, so they thought they had a lower risk of genetic discrimination, versus just the I'm Black as the explanation for why they thought they had higher risk of discrimination. Now, keep in mind, this survey went out June, July 2020. So we were also at the very height of George Floyd and Black Lives Matter protests. So I think that also probably has something to do with how people, it was at top of mind, would be my guess. And then the final theme that I'll note is how people think about how they trust the laws or protections, right? Gina's good enough to protect me from genetic discrimination, or I don't trust insurance companies. So no matter what the probability, right? Money rules all. So for some people, no matter what you tell them about the law, they very well might not feel assuaged. And for some, they say, oh, there's a law, so we feel good. Okay, so to think about what this means for informed consent, what do these findings mean? Well, I think there's two ways to look at this. One is to say, if we tell people more about risks and gaps in the law, we may be unnecessarily increasing worry, especially when there's not much empirical evidence that these risks are actually happening. On the other hand, informed consent, the whole goal of informed consent is to give people information that they need to decide whether or not they're going to participate in research. That's the autonomy that we're protecting and the ethical norms of informed consent. So if we have evidence that says a number of people will decide not to participate if they're fully informed of the law, then we're putting the informed consent to include that. Right? So I'll stop here because I want to talk about sort of broader implications for research at large. But I just wanted to take a pause in case anybody had questions about the empirical research itself. Right, explained it perfectly. Okay. So how can we think about this for broader research? And I'll actually put a plug out there. How do you think about this for just describing laws to a client for the first time? Right? How do you think about actually explaining to somebody what protections are versus what protections aren't? Because that's a really hard balance to bring about. And so I think this has implications not just for genetic discrimination, but I think it has implications for a whole host of privacy risks within research setting. We could also talk about clinical care and informed consent in clinical care. That's a little bit harder. It's a little bit different of a situation. In research, you often are enrolling and you sit down with somebody and talk about the consent procedure, whereas in clinical care, you might be like 10 minutes with the doctor and they're kind of doing stuff. You know, for something like surgery, you're gonna have more of an official informed consent process in clinical care, but for other stuff, people. So it's a little bit more complicated. Okay, so here's two ways we can ask this question. How should privacy and discrimination risks be communicated in informed consent? Another way to think about it is, to what extent is it the role of informed consent to tackle issues of statements of law versus some contextualization of what the gaps in that law mean? So if we think about the person who said, I'm on Medicare and retired, do we need to change how the informed consent that they get? Because we don't need to add a whole bunch of gaps because they don't apply to them. Or do we need to, not do that? Just give something basic. So to give a little bit of more black letter part of this, research is regulated by the Common Rule. This is the federal administrative rule that regulates human subjects research. And it sets a reasonable person standard for informed consent. So this is not necessarily the case in clinical care. In clinical care, about half the states have a reasonable patient standard, about half the states have a reasonable provider standard, what the reasonable provider is. But for research that's federally funded, it's the reasonable participant standard. And so they have to be provided with information that a reasonable person would want to have in order to make an informed decision. And this includes the foreseeable risks. And those foreseeable risks include things like privacy and confidentiality risks, which is part of why HHS includes the description of GINA for any genetic studies. Okay, but if we think about research, there are a ton of foreseeable sort of quasi-legal risks, not, I don't mean legal like you're gonna get sued, but legal risks in terms of privacy and discrimination that's protected from in a legal realm. So there's a lot of things that are changing in research. We have huge, large-scale biobanks or data repositories where if somebody's joining a research study, we're pooling hundreds of thousands, if not millions of people's data together, and we're collecting a whole bunch of it from a whole bunch of different sources. And then we're doing really cool research on it, right? And there's a lot of broad data sharing. And then I keep talking about clinical care and research, but in actuality, those are increasingly blurred. But we have different laws for those two different silos. And so it's really confusing for how to inform somebody about their protections in a research realm when their data is moving back and forth between research and clinical care. I'll give some examples of that. Okay, so all of this leads to a whole host of both unintended and anticipatable privacy and discrimination risks. I say, here's one thing, if you write a paper and you use a word like anticipatable, remember that you might have to like say it in a presentation. Anticipated, could be anticipated. Right? So here's an example. Any NIH study that gathers sensitive information, including identifiable information, automatically gets what's called a certificate of confidentiality. This means that if a researcher is subpoenaed for information, let's say they're doing a study on drug use or a study on, something like that. So if they're subpoenaed to say, well, who actually is, doing illicit drugs in your study, the certificate of confidentiality says, no, that information is protected and we actually can't give that information up. So informed consent documents will start to list off that there's these certificates of confidentiality. Two things. There's some gaps in certificates of confidentiality that haven't been tested much. In some cases, even when there's been a certificate of confidentiality, courts have said you still have to hand over some information. So there's some like, how many gaps do you actually list? But then there's some we know. If the information from a research study is placed into a clinical medical record, the certificate of confidentiality no longer applies. Right? The certificate of confidentiality only speaks to research data. It does not speak to medical data. But there's all sorts of studies that place research findings in medical records because then you can act on the information, right? We can think about a genetic study that finds predictive genetic information. It's really helpful for the individuals to have that data in the medical record so that they can access those early screenings. Well, if their informed consent only says, you have this law about certificates of confidentiality and we're protecting your information, but it doesn't mention that gap, that by having the study designed this certain way, your information changes protections, right? Then is that something a reasonable participant might want to know and could reasonably affect their participation in the study? And maybe if it's something about illicit drug use or something where they think they could be in real legal danger. And so I argue what this means is that participants need to understand both the legal protections and all of the limitations to fully assess privacy risks. But just stop and think for a second. Like, think about any law that you recently learned about privacy in the US. How complicated is that to write down in a clear and concise way for somebody to read, right? So disclosing all of those protections in practice is so complex. And here again, I'll go with like, you can go too much or not enough, right? This is the Goldilocks conundrum. We're trying to find that middle ground throughout the whole thing here. So if we give too little, I think we risk having people consent to something where they don't truly understand what they're consenting to. And they're taking on more foreseeable risks than they might actually be willing to take. If we disclose too much, there's already evidence that people don't read informed consent documents. They don't understand the really, really impactful things like there's a surgery in this and you might have a medical complication or something like that, right? And it could lead to anxiety and worry that is unfounded in some cases. And so how do you balance this? So I argue that one way to balance this is through contextualization, what I was talking about before. Do we really need to tell somebody who's retired and on Medicare about all the gaps in GINA when that's not something that likely would affect them, right? So we could think about this and say, well, why don't we only provide the information that's directly relevant to each participant? Okay, great in theory, impossible in practice, right? So a couple of problems. You write the informed consent documents before you know who's going to be the person enrolling in the study, right? You get them approved through this whole system. So I don't know whether I'm going to have somebody retired enroll in the study or somebody who works for a company with 5 employees. We also have a slight problem that contextualization, what does it require? It requires the practice of law, right? In some cases, if we go too far down the line of really contextualizing what somebody's legal risks are and what laws might apply to them and in which state and all of this stuff, then we're being a lawyer to that person. And the vast majority of people giving consent or consenting an individual are, genetic counselors, research assistants, doctors, not people who have a law degree and are licensed to practice. And so one, there's unlicensed practice of law, which could be an issue, but also there's just expertise. Is it really, is the person who's going to be consenting, the person really understanding all the complex rules of privacy laws and federal law and state law and which preempts which and all of these cases. Okay, so here's my proposal. I think that we should there's things called institutional review boards or IRBs. IRBs have to approve human subjects research done with federal money. And it's already a whole system. You have to go through a complex process to make sure that the informed consent document, they're already approving the informed consent document, making sure that's okay, making sure that your confidentiality practices, that you're keeping data in secure locations, that your data sharing practices are okay, that you're not putting subjects at too much risk. So I think that IRBs should do some contextualization, but at the group level. So what do I mean by that? Well, I might not know each individual that's going to enroll in my study, but I know something about the contours of who I'm looking at. Okay? So I might be targeting, adults above 55 in this geographic location. Well, if I'm doing that, then I know, well, maybe a little bit less risk of genetic discrimination, but maybe, some privacy risks or something about this. Or I'm looking at individuals with Huntington's disease or who are at risk of Huntington's disease. Okay, well there, we might really want to dig into all the gaps because we know that that's going to be something that's really of interest. And one example that is published and came up was a study where they were doing genetic testing within a military context. And GINA specifically doesn't include the military, and yet they were using the boilerplate form about GINA and the protections when it doesn't have anything to do with that study population. So if you can think, if the IRB has to say, well, does this work for the study population, then we might be able to help with a little bit of that contextualization. It's not going to be perfect, right? These can be clunky. Studies can be huge, and so you might have every single type of person out there, but at least we can start to get some level of trying to disclose the privacy risks and the confidentiality risks and the discrimination risks that really work for the study context and the study population. So here's how I think that this could go about, right? Is the IRBs in tandem with researchers think what legal protections might be necessary to disclose, given unintended and anticipatable information sharing, right? So are you moving stuff from a research record to a clinical record? That's going to raise different things. We might need to talk about HIPAA or, in more detail, other privacy laws, right? And then here's the contextualization. Which of these privacy and discrimination risks might be most significant or likely for that particular research population? And in that case, we want to narrow in on those most likely concerns. Otherwise, we risk over disclosure. Right? And then sort of within that, right, are there any known special risk factors that necessitate disclosure for a particular legal protection, or most notably its limitation? So I'll leave it at that, and I'm happy to chat about either the sort of more genetic specific piece or how we can think about this in privacy and discrimination at large.
So we got a few minutes for questions. So people have questions. If people online can't really hear me, but if you're online, you can also just type in a question.
Yeah, so if you're online, you can type in a question in the chat, and it'll get called out. Yeah.
There's been like some discussion about informed consent laws, at least in the clinical context, moving to more like discussion-based rather than form-based. I don't know if there's like any way to do that with research, or if there's things about that.
Yeah, for sure. So there's like shared decision making is one way that this is happening. So there's all sorts of ways where the provider and the patient sit down together and talk about values and talk about risks and benefits and weigh that, right? So I think there's definitely ways to do that. There's some studies that have looked at informed consent in the research study, and what they do is ask first what a value is, right? What is somebody's value? So in this case, you might ask, how much do you care about whether X entity has access to any of your personal information? And for some people, they might say, I don't care, right? I put everything on Google and social media anyway, and so I don't care if it comes to them via research. And if that's the case, then you might not have to disclose as much, because their value isn't, it changes it more to a subjective standard instead of an objective reasonable person. It says, well, then we might not have to give this information if that's not of value to you, or we could emphasize it less. I think there's definitely some room for that, but that is hard to implement then with these really large scale research projects, because it does take a little bit more than analysis of how that values fits in with actually the protections.
So I have a question online, which is, how do you recommend approaching IRBs about changing, updating their approach to informed consent?
Yeah, I mean, so a couple things. IRBs think about this a lot, or think about informed consent a lot. I think the challenge here is that it's almost talking to the legal team at the university more than talking to the IRBs, right? So the IRBs will sometimes require boilerplate language of this has to be in the informed consent. And the boilerplate language is most likely to be the ones that is developed and vetted by the lawyers, right? And they're most likely to be around all these legal protections. So in some ways, it's having a broader conversation with the IRBs, but also with counsel at the university to say there has to be some flexibility here. Can you give multiple versions of that boilerplate language so that we can make this the best for the group at hand? Because then that's really a problem if you can only put the boilerplate language in. So there's evidence out there that people will say, oh, here's this language. And then when they're consenting to somebody and they're actually talking with them, they say, oh, ignore that part. We just have to put that in. But that doesn't do anything for informed consent, because then that only works for the people who are having the conversation and not just reading it. But also, that just is clunky. I mean, that's what makes informed consent documents so long, is that we're putting in this additional information. So I think it's partly having a conversation with the lawyers being a little bit less possessive over like the language that has to be used, but we're all training to be lawyers here, right? It also makes sense that they want really clear statements of law so that it doesn't come out. So I think there just needs to be some work there. Yeah.
What metrics would you suggest an IRB to use to compare a group approach to the status quo, or what results would you want to see if that approach was taken to show that it was successful, or it needed to be even more dynamically approached, even having more subcategories?
Yeah, I mean, it's a really hard question. This is really hard to play out in practice to find that just right balance. I think one piece is it's going to be easier to measure the over information, right? It's going to be easier to say, did you give information that just is not relevant to that group at all, right? And so we could probably do that by just looking at the study and looking at the population, and that's all, you know, in documents to say like, oh, we're in the military base and we're giving this information about, you know, non-military protections or something like that. I think it's going to be harder to see when there needs to be more information added in. And I don't know. I don't know a good answer to that. It's a really tough one to have that work out in practice. Because if you walk too far down that, right, and say we need more and more and we need more and more groups, then we get into the just difficulty of personalization, right? Which goes back to Cassandra's question of, I mean, I think there's ways to do it, but it just makes it difficult.
How do you figure out the right level of customization, right? So what is the end goal? What do you want the people who are participating in these studies to know, to feel when you're arriving at kind of the sweet spot of the group level customization? What's the end goal? What should somebody have at the time that they're making this decision?
Yeah, I think here we think about both the legal standard and the ethical standard. So the legal standard is information that a reasonable person would want to know when joining the study. And so there I think, okay, if I could really sit down and talk to somebody for hours about all of this, right? And I say, okay, Gina does this and it doesn't protect in these areas. And they go, whoa, no, I wouldn't want to do that. And then I say, okay, but here's what the study is about. It's about these conditions that don't show up in the actuarial reports about this. So the likelihood that this would be used by a life insurance company against you, probably pretty low. Like if I actually sat down and did the lawyering with them, where might they come out? And so that's hard to implement in practice, but I think that's what we have to remember is the underlying goal. Because it's not just the legal standard, it's the ethical principle behind this, that if we're going to ask people to participate in research, we need to respect their autonomy and allow them to make the risk-benefit calculus, because for research, the benefit is for the good of society and the risk is all for them. And so I think I'm a very privacy-oriented person, but I tend to say we need to skew a little bit more on the over-disclosure if we're going to respect those choices. And even if we lose a few people who say, well, I'm not going to participate, I think that's respecting them. So that would be where I fall. And again, remember, we found that although there was a statistical difference, most people said they would participate in that study, right? It's just that it was slightly fewer when we gave them more information. Yeah.
Do you ever talk about how genetic information from like a parent or a child and how that works? Because I imagine that dances the line between personal autonomy and also carrying on.
Yeah. Yeah, definitely. So, and this comes up all the time and does make it challenging, at least for the genetic privacy piece. So my example of, well, we have a retired population and they're, not employed and have Medicare kind of falls apart if they're worried about their kids who are currently employed. And there are evidence. So in a previous study that I was part of at UNC, we looked at why people who were older than 80 joined a genetic testing study where the information they were getting back wasn't clinically relevant for them at all. And a lot of it was, I'm doing this for my family because I might get information that would be for my family, which then also means that legal information would be important. So here we could go to the shared decision-making piece as well of, how important, right? How do you view privacy? Do you worry about, that information for family members. I do think in terms of balancing the likelihood, right, we are one step further removed from the likelihood of discrimination because it's now a family history of something as opposed to your personal genetic information. So I do think in terms of balancing out likelihood versus the risk, it is still a little bit lower risk for the family. I'll throw out one other finding that I just think is so interesting. I think also helpful to think about how you talk to clients in the future. So one of the things that we did in the study was later we gave them a different consent that they hadn't seen before, one of the different versions. And we said, now, if you had read this one instead of the other one, would your willingness to participate change? And so some people had been given either the comprehensive or the basic consent that showed some gaps in GINA. And then the second time around, they got the minimum, right? Which was no gaps in GINA displayed. And in the qualitative findings, in the open-ended findings, they said, I worry less about discrimination because the things I was worried about are no longer a concern. Okay. The law didn't change. The scope of the law didn't change. What changed is calling out what those protections were. It's like object permanence. You know, when you're a little kid and you can't, like if the thing's not in front of you, you don't know what happened to it. That was what our participants. This is the qualitative, right? So this is just anecdotal, but at least some, if you didn't specifically say, here's what the gaps in the protection are, they were like, oh, there's no more gaps. We're totally fine. So just throwing that out there and thinking like how you communicate legal protections. It's really important to be really explicit that it's not just, here's what's covered. If you know, and your client's like, cool, my lawyer described the thing. And then turns out they just didn't like take the leap to say, oh, that means that part is open to the gap. So really interesting to see how people react to this sort of information.
Professor Prince, because it's a study on their willingness to participate in the study, and the fact that they wouldn't be participating in the study if they weren't willing to participate in studies to begin with, how is that accounted for?
Yeah.
All this, like I'm not up on all the university study stuff. I just want there has to be some kind of accounting for that, right?
Right. So yeah, so definitely a limitation that we're already picking people who are research minded. Right? We were not collecting any identifiable information. So I have no idea who those people are, right? There was this other service that they just have an app on their phone and, you know, fill out surveys all the time. So it could be, so I think there's a couple ways of thinking about it. It could be that we had more people who said, yeah, I'd be willing to participate because they're already totally fine with giving their information out for research. It could be that they might think about a participation in biomedical research where like blood is collected or some sort of information is collected differently than I'm filling out a survey about how I think about participating in research. But it's a point well taken that that's definitely a limitation that we had to get people who were totally okay with.
It's like a choice either, so like I get that.
Yeah.
So you got to use somebody, and those are the people that will. So.
Yeah. There are some studies out there where there's an actual, I know the ones in the genetic space, so there's an actual genetic study going on, and people who say, yes, I will participate, and then people who say, no, I won't participate. And then they take those people who say no, and they say, could we actually ask you why? Like, will you at least consent to talking to us about why you don't want to participate? And some of those studies have found that like there was one that found that I think it was like 25% of the people who said no was because they were fearful of genetic discrimination, and particularly insurance. So that's doing it a little bit backwards, where you're taking people who who don't want to participate in research, although they're involved enough, they're interested enough to like have their name be in the system, but then they say no. So some ways of triangulating that could work out.
So, which is when you were describing the ideal of, having the lawyer sit down and kind of advise them individually. I almost wonder whether it would be better to have an independent third party that was responsible for handling the consent piece to avoid the over disclosure or under disclosure, right? So the incentive for the researcher is to disclose as little as possible so they get their study finished in. The incentive for the council, the university council, is to make sure we disclose as much as possible because we don't care whether you get people on your study, we just care that we're not going to get sued, right? And so almost like having an independent third party that can be out there balancing the interests of the individual. Is that a possibility at all, or does that make it too complicated?
Yeah, I mean, it's interesting. I mean, in some ways, there's sort of a little bit of a medium between that, in that I'm thinking of more clinically based research where there's concerns when the person's doctor is the one who's actually doing the research, and then they sometimes have like a intermediary research assistant do the consenting so that it's not coercive. Like I might feel that I'm not going to get treated at all if I say no to this. That's still somebody involved in the research team. They're just a little bit, they're not the PI of the study or like the main person of the study. I think it gets really complicated because one of the challenges here is that I'm just talking about the legal risks. And then there's the medical risks of the study. And sometimes those are quite small. In the case of the study that I did, it's just collecting data. There's no medical risk. The only risk is privacy and confidentiality related. But for some, it's a blood draw or something much more severe, right? It's taking out a tumor or something like that, right? There's other ways, or a clinical trial where you're taking a medication. And so how you would translate that to some that really you need both the medical expertise and the legal expertise, I think it's hard. So then what do you do in that situation? Have, the doctor describing the medical parts and then this intermediary talking about the privacy risks, maybe, but I think that would be hard in practice. Whereas the IRB, one of the reasons why I moved towards the IRB is because they as a collective either have all of that expertise or they have access to like the general counsel at the university who has that expertise that they can bring in. Well, thank you very much for your time, and we'll hopefully see you for the rest of the presentations this semester. I'm really excited for all of them to come as well. Thanks.